All right, hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today we are going to talk about how to initiate your case if you are post-decree or post-order. So you've gotten divorced and you have a divorce decree, or you've established custody and you have a custody order and you want to modify it. So you want to change that decree or order, or you want to enforce it. So we're going to talk about how to initiate that process, how to serve the papers, and then also how to file a response if you've been served with papers to modify or enforce. We are going to take this in a 5-step process. So number one, we'll look at case initiation, and that's going to be this first video. In the second video, we will look at step 2, when the order to appear is issued, and we'll also cover step 3 about service of process. And then in the next video, we'll cover the optional response to the petition. And then we'll do a video about the next steps and a summary of what we covered today. All right, first thing to keep in mind when you're in this post-decree, post-order place is that the court procedure is different from what it is for a divorce or a custody establishment case. So I'm going to walk you through the steps of the procedure. So the first step is to initiate the case by filing the petition, the order to appear, and all other required forms. And we're going to go over those forms today. Once the case is filed, it's then taken to the judge that's assigned to the case, and the judge is going to review the petition. Based on the judge's review, the judge will decide if there's sufficient grounds to set a hearing and issue the order to appear. If the judge finds insufficient grounds, then the judge can issue an order dismissing the petition. Also, let me go back to point 3. The judge could also issue an order telling the petitioning party what they need to do. Like if there's some technicality that makes their petition insufficient, the court could instruct them to make the change and give them a deadline to do so. And if they don't do it by the deadline, then dismiss the case. Or if the judge just finds it completely insufficient, the judge could just dismiss it. Alternatively, if the judge finds there's sufficient grounds to proceed based on what's in the petition, then the judge will issue the order to appear by setting a hearing date. Most often, the judge sets what's called a resolution management conference, and then at the resolution management conference, will set a date and time for an evidentiary hearing. However, the judge does have the option to immediately set an evidentiary hearing. So we've got this process where you file your case, the judge reviews what you filed. If the judge finds that your filing is insufficient, the judge can ask you to correct it, or the judge can dismiss your petition. And then if the judge finds that your petition is sufficient, the judge will set a court date. And it's either going to be for an RMC, a resolution management conference, or an evidentiary hearing. What can you request to modify? If you're going to file a petition to modify, in other words, change what's in your current court order, what can you request to change? Well, you can request to change legal decision-making. So if you have sole decision-making and you want to change it to joint, or if it's joint and you want to change all or part of it to sole decision-making, that's something that could be requested in a petition to modify. Also, changing parenting time. This, I would imagine, is the most common request because as your children get older, they're going to, the schedules are going to change. You're going to change with your jobs, potentially where you live. There's all sorts of changes that can unfold and that can create a need to change the parenting schedule. So that's very common, to change the parenting schedule. And then there's child support. If either party has a change in income, or there's a change in who's covering medical insurance for the children, or various other changes, that can justify a request to modify child support. When child support is put into place, which would happen upon a divorce with minor children, or upon establishing custody. If one parent is ordered to pay child support, then there's another order entered called an income withholding order. And this is an order to the paying parent's employer, telling them how much in child support to withhold from their income in their paycheck and to send to the child support clearinghouse to pay child support. An income withholding order can also apply to an award of spousal maintenance. So it's an order to an employer to take money out of the payer's paycheck and send it over to the support clearinghouse to cover child support and or spousal maintenance. Now, if there's been a change, let's say the spousal maintenance and or child support has terminated, then that would be reason to modify or terminate the income withholding order. So that can be a very common request as well, as children age out of the child support and spousal maintenance obligations end. Spousal maintenance can also be modified if the decree states that spousal maintenance is modifiable. What can you request to enforce? Now, you can enforce child support, spousal maintenance, payment of medical insurance for the children in common, payment of uncovered medical expenses for the children in common. Now, this is pursuant to your underlying decree or child support order. So, for example, if your underlying decree or child support order says that medical insurance is going to be paid by father and father stops paying it, you could enforce that term. If your child support order says that uncovered medical expenses for the children will be divided 50-50 between the parents, and one parent hasn't contributed their 50%, that can be grounds to enforce. Now, generally, if you have this non-payment issue, the parent looking to enforce, they generally first need to pay the full amount and then seek reimbursement from there, because that's when they have those damages. They've paid out of pocket for the other side's expenses, and now the court can order the other side to reimburse them for what they paid on the other side's behalf. Now, one difference here is that you can't seek to modify, you cannot seek to modify the division of marital property, but you can seek to enforce it. So in a divorce or legal separation, the terms regarding the division of marital property are final. However, those terms can be enforced. And so that's the only time you're going to be able to bring a post-decree petition regarding the division of marital property. You're not going to be able to seek changes to it, but you can seek to enforce the terms. Parenting time can also be enforced, as well as legal decision-making. Yes, you can request to modify and enforce in one petition, but make sure it makes sense in your case to do so. You may want to enforce legal decision-making and modify parenting time, or enforce child support and modify parenting time. So you can do these together if it makes sense. What if your decree or order requires mediation before requesting to modify? Do you have to go to mediation before you can file your petition to modify legal decision-making and or parenting time? This is covered under Rule 91D. No party may be required to submit to mediation before filing a petition for modification of legal decision-making or parenting time. But keep in mind, there could be a local rule or court order that requires the parties to submit to mediation before the court will hold an evidentiary hearing, which is a trial on legal decision-making or parenting time. So very often in underlying decrees and orders, there's language stating if the parties reach an impasse, then they need to go to mediation first before going to court. And what Rule 91D says is that, okay, you can have that in your court paperwork, but the law is not going to require you to go to mediation before you file a petition to modify legal decision-making or parenting time. But keep in mind, once you file that paperwork, the court may require you to go to mediation before having a contested trial. What do you have to include in a petition to modify and or enforce? You need to include the date the judgment was entered, the name and location of the court that entered the judgment, and then you can attach a copy of that judgment that you're seeking to modify or enforce. But let's say that order, let's say that decree or that custody order, let's say you got that out of the same court that you're now going back to modify. Then this order is already a part of their court file, and you can just include language saying that it's incorporated by reference. So you don't necessarily have to include the entire order. For an enforcement action as well as a modification action, you need to identify what parts of the underlying decree or order you're wanting to change or enforce. So the page numbers and sections within your underlying decree or order that you're wanting to change or enforce, you need to identify those in your petition. And then the relief you're requesting, what do you want the court to do? So for the modification, if you're saying, I want parenting time modified, what's the new parenting plan you want? If you want child support modified, what's the new child support amount you want? For enforcement, if you're saying the other side violated the parenting plan, what's the remedy that you want the court to order for that violation? Now, specifically, if you're dealing with legal decision-making and or parenting time, and you're requesting to modify legal decision-making and or parenting time, then your petition has to include facts showing there's been a substantial and continuing change in circumstances that warrants modifying legal decision-making and or parenting time. So you don't get to just modify because you want to. The law requires a showing that there's been a substantial and continuing change in circumstances that warrants the modification. Now, this doesn't have to be extremely complicated, but it needs to make sense. So for parenting time, for example, you need to change the schedule because the kids are in different schools now and their school schedule is different and there needs to be changes, or the kids are doing different extracurriculars and there needs to be a new schedule. Those are substantial and continuing changes in circumstances that merits modifying the parenting plan. Let's say you put your parenting plan together and your child's an infant. Well, as they get older, you're going to need a new parenting plan because it's a different type of parenting plan for an infant versus an older child. That's, the child getting older and having a different schedule and having different needs is a substantial and continuing change in circumstances. So just keep that in mind for any request to modify legal decision-making and or parenting time. You're going to have to justify it, show that it's warranted, show that there's been a substantial and continuing change. If you're requesting to enforce, then you need to show what the underlying order is, the other side had notice of it, the parts of the order they violated, the detailed facts describing their violation, and the specific remedy or remedies you're asking the court to order. So what do you want the court to do about the violations? Now, if you're dealing with a petition to modify spousal maintenance and or child support, or a petition to enforce child support, here's some additional information. So number one, if you're looking to modify spousal maintenance and or child support, there's this same standard. In order to modify, you have to show a substantial and continuing change in circumstances that warrants modifying spousal maintenance and or child support. If you're requesting to modify child support, you need to attach a copy of the current child support worksheet. And then also your proposed worksheet, what's with the new amount you want the court to order. So show what the current amount is under the current order and what you want the court to change it to. And then if you're dealing with a request to modify spousal maintenance and or child support, then both parties are required to file and exchange affidavits of financial information within 20 days of the papers being served. Now, regarding enforcing, and this should be child support and spousal maintenance, calculating the arrears. If you're looking to enforce spousal maintenance and or child support, the court wants you to provide a summary of what's owed. So you can either get that from the clearinghouse, the support payment clearinghouse, where the payments go through, or you can create your own statement of sums due. Now, for child support, for medical, dental, or vision costs, if you're requesting enforcement of any of those types of costs, then with your petition, you need to include a statement of all sums due. Also, within 30 days after filing your petition, you need to disclose to the other party any documentation supporting the claim, including proof that you paid it. Now, here's an example of the unreimbursed medical and dental vision care expenses. So when we go back to the last slide, it talks about this statement of all sums due. This is an example of what a statement of all sums due form could look like to attach to your petition to show what you're saying is owed and should be enforced. All right, we're now to step one, case initiation. With that background laid, let's look at the forms to draft an e-file to request to modify and or enforce a decree or order. First, you're going to have potentially a court cover sheet. Again, this is going to be dependent on your county. So be open to, seeing if there's something a bit different in your county. I'm going to show you a few different forms. And then there's this confidential information form. There's the order to appear, and there's two types of orders to appear. There's one that's pre-decree, pre-order, and then there's this post-decree, post-order one, and that's the one you want for a modification or enforcement case. Now, in certain counties like Yavapai County, they also want you to file a petition for order to appear. I'm going to show you that form, but I don't believe they require that in Maricopa County. Then there's your petition. And just note, you can only seek to enforce the division of marital property. You can't seek to modify that. If there's minor children at issue in your modification or enforcement case, and they haven't lived in Arizona since the entry of the last order, or at any time, or the last order was not entered by an Arizona court, then you'll need to draft and file this affidavit regarding minor children. If you're requesting to modify parenting time, you'll need to file a parenting plan proposal. And if you're requesting to modify child support, you'll need to include a child support worksheet with the current amount and then a child support worksheet with the amount you're requesting. All right, here's what the Maricopa County sensitive data cover sheet without children looks like. So if you've got a petition to modify spousal maintenance and there's no children involved, spousal maintenance doesn't involve children, you can use this form. If you're looking to modify or enforce parenting time, decision-making, child support, you would use this form with children. And again, this is the Maricopa County form. This is the Yavapai County form. This is page 1. You don't file page 1 with the court, but it explains that Social Security numbers, bank account numbers, credit card numbers, other financial account numbers, and driver's license numbers are what fall under the definition of sensitive data. This is what the Yavapai County form looks like. And then also Yavapai County and other counties require this cover sheet, domestic relations cover sheet, that you need to fill out as well at the time of filing. Second is the order to appear. So again, this is that special order to appear for the post-decree order. And in certain counties, you may also need to do this petition for order to appear. So here's Maricopa County's order to appear post-decree. Now their set form automatically orders the parties to attend a resolution management conference. And I'm going to talk more about what that is later on in this presentation. But this order to appear form, you submit it like this, and you put in the case the parties' names and your case number and some of this information, but the court is going to fill out this part. So you'd leave that blank. So this is the Maricopa County form. This is page 2. And then this is what the Yavapai County form looks like. And this is a form very similar to what many rural counties use. So this is the order to appear post-judgment decree. And this is where you would fill out this part, the names of the parties, your case number, your atlas number, if you have one. And then here would be the opposing party. You're the party filing the case. The opposing party would write their name in here, and then the court would fill this out if the court was going to give you a hearing. And then this is that petition for order to appear form that Yavapai County requires, but not every other county requires. So you just go through this form and fill it out. So I just have a question. After divorce decree has been granted, can the other party go back to modify property division? No. Property division provisions are final. You cannot modify those. You can only enforce property division terms. Okay, so this is the petition for order to appear form that at least Yavapai County requires. All right, and then I just wanted to remind you, what can you request to modify? Legal decision-making, parenting time, child support, and income withholding order, or spousal maintenance. So let's look at what a petition to modify legal decision-making, parenting time, and child support looks like. This is the Maricopa County form. So you'd fill out this top part. If you want to use this form, but you're not in Maricopa County, you can scratch that out and write in the name of the county you're filing in. You'll keep the names of the parties the same. So whatever your caption looked like when you filed for divorce, it's going to stay the same. Or when you filed to establish custody, it's the same. So post decree, the petitioning party could be the respondent, but that doesn't mean the respondent's name now gets put as party A. It stays the same. However it was in your original order, the caption is the same. But in a post-decree case, the respondent can be the party that initiates the post-decree action. So I know that's a little confusing. Hopefully I did a good job of explaining that, but the bottom line is that your caption is going to stay the same. Don't change how the parties are listed on your underlying order. Write it all in the same. Now, I'm going to go back. So here's your name, indicate which party you are, A or B, and then fill this out, information about the parties, name and address, information about the minor children for whom you want the order changed, indicate if the children have resided in Arizona since the entry of the last order, or if the underlying order was issued by a court outside of Arizona, you'll want to do the affidavit of minor children. Otherwise, you don't have to do that. And then information about the order I want to change. So the order was issued on date. So the order, this could be your underlying establishment order or your divorce decree. The order was issued by the name of the court, the county, the state, and each of the following is true. Indicate that the children have been here for 6 months in Arizona, so long as that's true. And indicate if you're looking to enforce an order that was not issued by a Superior Court of Arizona. Indicate what pages, where are the parts that you want to change. Now, if it's on multiple pages, just add in additional information here. If you need to add an additional page and reference that, you can do that as well. So what the order says now, so write in the part of the decree order you want to change. Use extra paper if necessary. So you can use extra paper, indicate what's happened with domestic violence, if anything, why the decree or order should be changed. So this is about the substantial and continuing changes in circumstances. That's what should be here. And if you need extra room, you can use extra pages and attach them. You need to attach a current child support worksheet. So that's what the current amount is. And then I also suggest in here that you attach a worksheet for what you want it changed to if you're requesting to change child support. So here is where you're going to indicate what requests you're making regarding changing parenting time, legal decision-making, child support, medical, dental, vision care, the child federal income tax deduction, and then any other orders, sign it before a deputy clerk of court or a notary public, and that is your petition. Now, if you're requesting to modify parenting time, you also need to include your parenting plan proposal as an additional filing and the 2 child support worksheets, the current amount and the requested amount. Now, you could attach those to your petition, or you can have them as a separate filing. It makes sense to attach your child support worksheets to your petition. The parenting plan proposal is long, so it makes sense to have that as a separate filing. Here's just page 1 of the Maricopa County form for a parenting plan proposal. You can find the full form below this video, but just here's page 1 so you can see what it looks like. And then here's a blank child support worksheet. So when you fill this out in the Excel spreadsheet format, all of this populates out and gives you a final amount of child support. Okay, so as a review, these are the forms you're going to draft in e-file if you're requesting to modify legal decision-making, parenting time, and child support. So the court cover sheet, the confidential sensitive data form, the order to appear, plus the petition for order to appear if you're required to file that in your county, your petition to modify, the affidavit regarding minor children, if you're required to file that, if your children have been outside of Arizona or you don't have an underlying Arizona court order, your parenting plan proposal, and then 2 child support worksheets. So all of that is going to be filed, and I suggest that the 2 child support worksheets be an attachment to your petition to modify. And then keep in mind that 20 days after you file, or after you serve these papers on your co-parent, both parties are supposed to complete and file an affidavit of financial information. Okay, now let's look at another type of petition to modify. This is to modify an income withholding order. So an income withholding order is when it's an underlying order of the court, and it's an order to the payer's employer to withhold money from their paycheck to pay child support and or spousal maintenance. So this is a petition to change that income withholding order. So fill out your case caption, your name is here, and then indicate who is ordered to make payments, who's entitled to receive payments, all the information about the underlying order. The amount shown on the income withholding order is wrong. Now, this is an option, so you're going to check the appropriate boxes as to why the underlying income withholding order needs to be changed. So it's wrong because the amount was changed by court order. Okay, so you got a modification of child support, for example, and now you need the income withholding order changed. The person making payments no longer owes child support, like the amount has terminated, and so you can list why the amount is no longer owed. For the reasons listed above, the amount ordered should be changed, and so you'll want to show the current amount and then the new amount you're asking the court to change it to. Show the current income withholding order should be modified. This is if the presumptive termination date is wrong. So you check this box if you want to change the presumptive termination date and explain that. And then you'd sign this before a deputy clerk of court or notary public and move on to service, which we'll talk about in a bit. Now, here's an example of a petition to modify spousal maintenance or spousal maintenance and child support. So you'll see here, you can pick if you just want to modify spousal maintenance or if you want to modify spousal maintenance and child support. So, same thing, fill in your caption, fill in the information about the parties, information about your underlying order, and then information about other court cases to enforce or change this court order. So just fill this out as it applies in your case. And then if you're looking to change spousal maintenance, you want to explain what it currently is, what you want it to be changed to, and why. What is the substantial and continuing, or what are the substantial and continuing changes in circumstances that modify changing spousal maintenance? Child support. So what child support should be, and what are the grounds to change it? What are the substantial and continuing changes in circumstances that justify modifying child support? Indicate whether or not the Department of Economic Security is involved, and then sign. You'll want to attach your 2 child support worksheets if you're looking to modify child support, showing the current amount and your requested amount. That's what the child support worksheet looks like. Of course, this is a blank one. And then just as a summary, if you're going to be requesting to modify spousal maintenance and or child support, you got to file your cover sheet, your sensitive data form, your order to appear, the petition for order to appear if that's required, your petition to modify, the affidavit regarding minor children if you're requesting to modify child support and that document applies in your case, and then your 2 child support worksheets. And then remember, 20 days after service, you've got to file and exchange an affidavit of financial information. Okay, now let's talk about enforcement. What can you request to enforce? Child support, spousal maintenance, payment of medical insurance for the children, payment of uncovered medical expenses for the children, division of marital property, parenting time, legal decision-making. So this is finding a part of your underlying order that's been violated by the other side and then asking the court to enforce that provision. So let's look at a petition to enforce. Now, this is a broad one because you get to pick what you want to enforce. So child support arrears, spousal maintenance arrears. So arrears are amounts that are owed in the past that you have a judgment for. Medical insurance coverage, medical expense reimbursement. So you can select as many boxes as you want, as issues that are on the table for enforcement. Okay, this is information about the underlying order. For child support, you'll fill in the information there if you're requesting to enforce child support. Now this part is for spousal maintenance and or spousal maintenance arrears, fill that in. This part is for medical, dental, vision care expenses and medical insurance coverage. So if you're requesting to enforce those terms, you'll fill in this section. And then here's the request to the court. You can modify these or cross any out if you disagree with them. Sign, and then you're ready to file. So keep in mind that for a petition to enforce spousal maintenance and or child support, you need to include a calculation of what's owed. You can either request that from the support clearinghouse or create your own statement of all sums due. And if you're requesting to enforce medical, dental, or vision costs, you need to include a statement of all sums due. And then after filing your petition, you need to disclose to the other party the documents supporting your claim, including proof of payment of these costs. So these are some additional documents that you need to include with your petition, and then a step you need to take after filing. Here's an example of a statement of sums due for unreimbursed medical, dental, and vision care expenses. And you can use this form if that's what's at issue in your case. Let's look at a petition to enforce the division of marital property. So this is a petition to enforce court order about division of property. Fill in your case caption, change the name of the county if you're in a different county, information about the parties, information about the underlying order, information about other court cases to enforce, just to make sure that you're in the right court. So fill that out accordingly. All other court cases that involve these parties, so include that. Current case status, and then what the court order says, that I want the other party to obey. So include your information here. This is about personal property. explain exactly and with detail what the other person is doing to keep the property away from you, what you want the court to do about it. So that's all about personal property. This section is about real property, so real estate. You would fill out that section if that was at issue. This is about proceeds, so about the real property to be sold and the proceeds, you could explain that here. And then if there's something else going on with property that's not listed here that you want the court to consider, you could write in a number 9 and say, see attachment, and explain it there. And then fill out this additional information about what you're asking the court to do, sign, and then this petition is complete. Here is our final example of a petition. This is a petition to enforce parenting time. So no legal decision-making, no child support, no spousal maintenance, just parenting time. There's a form here you can use. Okay, so let's stop this video since that ends our section on case initiation, how to draft your petition, and the associated documents that you're going to include. In the next video, we'll talk about the issuance of the order to appear and service of process.